I'm Shannon Farrell with the OSU Department of Agricultural Economics, and in this part of the Farm Transition video series, we're going to talk about trusts. Now, trusts have gotten a lot of attention over the past few years as being very versatile estate planning tools, and they certainly are. They have a lot of advantages and can do a lot of things. They're very flexible. Trusts are the right answer for lots of situations, but they're not the right answer for everybody. So before you decide that you need a trust, we'll present some of the items that you should think about, talk about some of the various kinds of trusts, and then talk about what you need to consider if you're going to draft a trust for your particular estate planning needs. Now, when we talk about a trust in and of itself doesn't necessarily have to be that complicated. All it really is a set of instructions for managing a legal entity that owns property separate from the individual. If you want to think about a trust as kind of a little miniature corporation, that's kind of an analogy. You've created a separate legal entity that owns property by itself. So when you put property into the trust, you don't own it anymore. The trust does. Now, a trust can be very simple or it can be very complex. And whether it's simple or complex depends on how simple or complex your objectives are for what you want to achieve with the trust. In either case, though, your trust needs to be very carefully drafted. Just as we talked about with wills, there's lots of free forms out there and internet do-it-yourself kits, but a trust is an important part of your estate plan, and you really need to have a qualified, experienced, professional attorney working on your trust for you. Now, when we create a trust, trusts come with some powers already implied, but there are lots of other powers that actually have to be given to the trust by the person that creates it. So that's one of the things that you'll need to think about, and one of the things that we'll discuss, the powers that you can give a trust. Other powers, like we've talked about, that aren't implied, have to be specifically granted to you, and that's one of the things that your legal professional can help you out with. Now, when we talk about the parties that are involved with the trust, the first party is always going to be the trustor. That's the person that creates the trust and puts property into it. You can think of them as being the creator of the trust. The trustee is the person who's responsible for managing the trust, and they're responsible for legally representing the trust. They are, for lack of a better word, the human side of the trust. Then you have beneficiaries. Beneficiaries are people that either receive property or income from the trust. It's not at all uncommon that one person might hold all of these roles simultaneously. For example, if I create a living trust, I can be the trustor, meaning I'm the person that puts property into it. I can make myself the trustee. I'm the person responsible for managing the trust. And I can receive income or property from the trust, making me a beneficiary. This happens all the time, and like we said, is very common when we're talking about a living revocable trust, which is the primary kind of trust that we'll be talking about today. Now, speaking of revocable trusts, there are several different kinds of trusts. Two large categories include living trusts and testamentary trusts. Now, living, which you might also hear called an inter vivos trust, that's, as the name implies, a trust that we create while we're alive. Now, there are two subcategories of living trusts. There are revocable and irrevocable trusts, and we'll talk more about those here in just a second. Now, we could also talk about a dozen subcategories of living trusts, irrevocable trusts, revocable trusts, but that would take a video series that lasts for days, and we only have about half an hour to talk to you today. So we're going to talk about living trusts, and then we're going to talk briefly about testamentary trusts. Testamentary trusts are trusts that are created by a will. In other words, they're a trust that's created after we're alive. If we're talking about a revocable living trust, the primary reason that people create revocable living trusts is frequently to avoid probate. Like we talked about in our discussion of wills, wills have to go through the probate process to have legal effect. But if there's some other legal mechanism to transfer property, like a beneficiary designation, a life insurance contract, or a trust, they don't have to go through probate because there's a separate legal mechanism to transfer the title to that property. So the ability to avoid probate with a trust, but handle lots of different kinds of property simultaneously, is a big draw for lots of people, and the reason that they choose a trust as their primary estate planning vehicle. It doesn't have to go through probate, but it still should be coupled with a will, and we'll talk about that a little bit later on. But for right now, just know that there may be property that we meant to be handled by the trust, but for some reason we forgot to put in there. Well, a will can round up that property and place it into the trust, helping us achieve our estate planning goals. Now, understand that a revocable trust doesn't help us reduce our estate taxes. As Mr. Hobbs told you in the estate tax video, if we own or control property when we die, that property is considered part of our estate for the purposes of determining our estate tax liability. And if we have a revocable trust, we may not own the property, but we do still have control of it. That means it's still going to be included in our estate for estate tax purposes. So a revocable trust can't help us manage our estate taxes. It can, however, include property owned in other states. And when we were talking about wills, we talked about the fact that a will has to be probated in every state where it's affecting property. But a trust can be a one-stop shop. Even if we own property in other states, the trust only has to be administered from one state to be effective. If we talk about an irrevocable trust, now an irrevocable trust can't be terminated, just as the name implies. And the reason that you can create an irrevocable trust might be for estate tax management. Again, a revocable trust doesn't help with estate tax because we still have control of the property. But if we put property into an irrevocable trust, that means that we can't bring the property back to ourselves. It's out of our control and it's out of our ownership, which means it's out of our estate for the purposes of calculating our estate tax liability. And so that's one big reason why some people choose to use an irrevocable trust, is to manage that estate tax liability. Some people use it for asset protection. If you've put the property beyond your reach, that may mean, if it's constructed properly, that it's also beyond the reach of your creditors. For people that worry about their children perhaps spending the property or income from their trust, they may create what we call a spendthrift trust, and that's another variety of the irrevocable trust. Testamentary trusts, like we talked about, are created by our will, so they're created after we're alive. And there are a few reasons why you might want to have a testamentary trust created by your will. One of those is to hold property for minors. If you have kids under the age of 18, they can't legally have title to the property until they're over the age of 18. And so you might create a testamentary trust to hold the property until they've reached that age. You might also want to restrict the transfer of property. For whatever reason, you might want the person that receives property not to be able to transfer it to someone else or to hold on to it for a specified period of time. So a testamentary trust can be created to hold on to the property until that specified amount of time has passed. You might also want to require specific uses of your property. You may want to pass along farmland with the restriction that it can only be used for farming. Well, a will alone can't really do that effectively because the will does its job and then goes away. But a testamentary trust could be created to hold the property, and the trust could require that the property be only used for farming for the specified duration of the trust. So those are some of the broad types of trusts. Let's talk about the things that you need to consider when you're determining the actual provisions that need to be in your trust. First off, you need to figure out who's going to be the trustee. And like we said, if this is a living revocable trust, quite frequently the answer is going to be the person that created it. But many times we create trusts with the intention that they're also going to handle property after we're gone. And so in some cases, many folks, not wanting to treat their children any differently, make all of their children co-trustees. Now that's not necessarily a bad thing, but if you do have co-trustees, what you have to consider is what's going to happen if those trustees can't agree on the decisions regarding the management of the trust. You'll need to have some sort of way to break those kinds of deadlocks, and you might need to establish a hierarchy for decision making. There are lots of complexities involved when you have co-trustees, and that's one consideration that you need to weigh. On the other hand, it's almost always a good idea to have successor trustees. And a successor trustee is simply a trustee that steps up into the place of the primary trustee if the primary trustee can't or is unwilling to carry out their duties as a trustee. As we were talking about in the wills video, trustees, like executors, are considered fiduciaries. That means they're held to the highest standard of care, and all the other beneficiaries of the trust are going to be very carefully scrutinizing all the actions of the trustee. The trustee is a difficult job, and so you need to make sure that the people you select are up to that task, that they know how to manage the assets that the trust handles, and that they're willing to take on that kind of responsibility. That's why, again, the successor trustee is important. If they can't or are unable to fulfill that position, then you've got somebody else waiting in the wings that can pick up where they left off. You also need to figure out who the beneficiaries are going to be, and the possible beneficiaries are endless, and it can be whoever you want it to be. That's one of the tremendous elements of flexibility that trusts have, is you can make beneficiaries be anyone. Family members, spouses, friends, charitable organizations, you name it, the possibilities are endless. You just need to think about who those beneficiaries are. You'll also need to think about the duration of the trust. And trusts can last very short periods of time. If all you need them to do is to avoid probate, they can just last as long as you do. You pass away, the trust designates who receives the property, and then the trust winds itself up. But you can also make trusts last for a very long period of time. They can't last forever, and we have something in Oklahoma called the rule against perpetuities, which just says that a trust can't be endless. It has to have some defined endpoint. But that endpoint can be for multiple generations into the future. When we're talking about the rights of the trustee, these are kind of the powers that you're going to grant to the person that manages the trust. First off, do you want them to be able to buy additional property to put into the trust? Whenever you create the trust, you put property into it. But what happens if after you're gone, there's a piece of property that would be very advantageous to add to the trust? Do you want the trust to be able to purchase that property by selling other assets in the trust? Do you want the trustee to be able to sell assets in the trust? Some people intend that the property is always to be held by the trust and never passed along. That's something to think about. Do you want to give the trustee the power to lease property? And especially in Oklahoma, we need to think about leasing minerals and wind rights, because those are obviously hugely important from an economic standpoint. Do we want to specify what things the trustee can and can't invest in? If we intend that the trustee is going to invest some of the property in the trust into something that may be, not land, but an investment property, stocks, bonds, certificates of deposit, we need to specify what kind of things that trustee can invest in and by what standard we're going to measure those decisions. We also need to tell the trustee what their powers are as to when they can discretionally distribute trust income. They might have specific periods where they're required to distribute trust income to beneficiaries, but do we want to give them some discretionary power if there's some special need or something unforeseen happens to one of the beneficiaries? Also, along those lines, but even more serious, do we want the trustee to have the power to give property to the beneficiaries? Let's say a beneficiary has a large unexpected expense, like a medical emergency arises, and they need more money to pay their medical bills than the next several years of payments from the trust would normally be. Do we want to empower the trustee to be able to sell trust property to give them a large sum of money all at once so they can pay off those expenses? What kind of uses do we want to specify for trust income and for the property? This is another important advantage that trusts have that make them a little bit different from wills, in that you can actually create restrictions on what people can use the property for that they receive. Some of the frequent restrictions that we see on trust income are that the income is only used for educational expenses, that it's used for medical expenses, or if there's any special unique needs that one of the beneficiaries have. You can also affect the timing of distribution to the beneficiaries. You might specify that beneficiaries receive their timed gifts at specific ages. So perhaps when someone turns 18, 21, 25, 30, you name the number, or on the occurrence of specific events, when they graduate high school, when they graduate college, when they get married. Again, there's really no limit to those restrictions, you just have to think them through. Now, we've talked about a lot of things that trusts can do, but if I've got a trust, do I still need to have a will? Well, my answer is yes, because trusts can do a lot of things, but trusts are only as effective of an estate planning tool as you allow them to be. If we create the trust and intend for the trust to transfer all of our property when we pass away, well, then we have to be extraordinarily careful that we had all of our property in the trust. What happens if we left property outside of the trust? So even if we've got a really good, thorough, robust trust, a will still serves important roles. First off, it can point to the trust. When someone's passed away, it can remind the estate that there is a trust and that that trust was meant to be our primary estate planning vehicle. But also, it can serve an important function as a backstop. In other words, if we have what we call a pour-over will, that pour-over will can gather up any property that we haven't already put into the trust and place it into the trust so that now the trust does become that one-stop shop for our estate planning. Now, we've talked about a lot of elements of the trust. Let's talk about the pros and cons of a trust as an estate planning tool. On the pro side, like we said, many people like the trust as an estate planning tool because it avoids probate. Probate takes time, probate takes money, and most people would say, I'd prefer to have the trust handle all of this in a faster manner and not have to pay all the expenses of going through probate. Additionally, if we've got minor children under the age of 18, we can use the trust to hold property for them until they reach the age of 18 or some other specified age if we want them to be older before they receive the property. Trusts are not public information, and this is a sharp contrast to the will. Wills have to go through the probate process, as we've said, but the probate process is an open court proceeding, so everything filed in the probate case is open record and can be examined by anyone. Trusts don't need to be disclosed to the public, and they can maintain information much more confidentially. On the same side of things, trusts are much more difficult to contest. In the wills video, we talked about all of the execution requirements, the requirement of testamentary capacity, and how those things might be challenged in a will contest. Well, a trust is really, at the end of the day, a contract, and the requirements for forming a valid contract are much less than those for forming a valid will. So there's much less to contest with a trust, which makes them a little bit more robust when it comes to those contest challenges. Now, on the con side of a trust, if we have a trustee that's someone other than us, we're probably going to have to pay that trustee a fee. And so that can be an additional expense of putting property into the trust. But usually trustees' fees are relatively modest, and they're almost always a percentage of the value of the assets that are under management. Now, trusts also add a little bit of complexity to the management of the assets while we're alive, because remember, we don't own the property anymore. The trust does. And so when someone approaches us about buying land from the trust or leasing land from the trust, we can't execute that agreement in our own capacity. We have to execute it as the trustee. That's another layer of management that can add a little bit of complexity to things. Even if we have a trust, we still have to coordinate that trust with other estate planning tools. With our will, with our beneficiary designations, with our life insurance policies, all these things have to work together cohesively in one plan. We can't just let our trust operate exclusively with other items, or even worse, we can't have a trust that conflicts with the other items, because that's an opportunity for litigation. And last but not least, even if we've got a trust, we do still need a will for the reasons that we just talked about, to round up any property that we have that isn't in the trust and get it in there so the trust can serve its role as our estate planning tool. So to review what we've talked about today, we've talked about trusts basically being a separate legal entity that owns property apart from ourselves, but that's what gives it the power to avoid probate, because it can survive us, and it's a separate arrangement for the distribution of that property that legally empowers it to avoid the probate process. Now, when we have a trust, we're going to have a trustor, the person that puts property into the trust, a trustee, the person that manages it, and the beneficiaries, the people that receive income and or principal from the trust. There are several different kinds of trusts, more than we can talk about today, but the basic categories are the living, revocable, and irrevocable trusts, and then the testamentary trusts. There are lots of decisions for the trustor, and we've talked through all of those points, and at the end of the day, the trust has a lot of value as an estate planning tool because it can help us avoid probate, but we do front load some of the expenses rather than backloading them by going through the probate process. Now, we've talked about a lot of things today. Trusts are very complicated instruments, but we've included lots of information about them, checklists of things that you need to go over, all on our Farm Transitions website. That's at agecon.okstate.edu/farmtransitions. I'm Shannon Farrell with the OSU Department of Agricultural Economics. Thanks for watching.